Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Environmental Protection Agency v. Calumet Shreveport Refining, L.L.C. In this case, the court considered this issue. Should challenges by small oil refineries seeking exemptions from the requirements of the Clean Air Act's Renewable Fuel Standard Program be heard exclusively in U.S. Court of Appeals for the D.C. Circuit because the agency's denial actions are nationally applicable or based on a determination of nationwide scope or effect? The case was decided on June 18, 2025. The Supreme Court held that EPA's denials of small refinery exemption petitions from renewable fuel requirements must be challenged in the D.C. Circuit because they are locally applicable actions based on determinations of nationwide scope or effect. Justice Clarence Thomas authored the 7-2 majority opinion of the court. The Clean Air Act establishes a tripartite venue system for reviewing EPA actions. Nationally applicable EPA actions must be challenged exclusively in the D.C. Circuit, while locally or regionally applicable actions ordinarily belong in regional courts of appeals. However, locally or regionally applicable actions that are based on a determination of nationwide scope or effect must be reviewed in the D.C. Circuit if EPA finds and publishes that such basis exists. To identify the relevant action for venue purposes, courts must look to the specific statutory authority EPA is exercising rather than how EPA packages its decisions. Each EPA denial of an individual refinery's exemption petition constitutes its own action because the Clean Air Act allows each small refinery to petition EPA separately and requires EPA to act on each petition. An action is nationally applicable if it applies on its face throughout the entire country. Alternatively, it is locally or regionally applicable if it applies only to particular places. EPA's denial of a single refinery's exemption petition applies only to that specific refinery in a particular location, making such denials paradigmatically locally or regionally applicable actions. The nationwide scope or effect exception applies because EPA's statutory interpretation and economic theory formed the core basis for its denials. A determination refers to EPA's justifications for taking action, and determinations have nationwide scope if they apply throughout the country as a legal matter or nationwide effect if they apply as a practical matter. An EPA action is based on such a determination only if that determination lies at the core of the agency action and forms the primary explanation for EPA's decision, requiring more than but for causation. EPA's interpretation of disproportionate economic hardship and its RIN pass-through theory constitute clear determinations of nationwide scope because they apply generically to all refineries regardless of location. These determinations formed the core basis for EPA's denials because EPA used them to reach a presumptive resolution to deny all petitions, then considered refinery-specific factors only to confirm it had no reason to depart from this presumptive disposition. Where EPA relies on determinations of nationwide scope or effect to reach a presumptive resolution, those determinations qualify as the primary driver of its decision, making EPA's confirmatory review of refinery-specific facts merely peripheral by comparison. Justice Neil Gorsuch authored a dissenting opinion, joined by Chief Justice John Roberts, arguing that the Clean Air Act's substantive provisions do not call for EPA to make determinations of nationwide scope or effect when acting on individual small refinery hardship petitions, and that the majority's new test will make simple venue questions unnecessarily difficult and expensive to resolve. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Thomas delivered the opinion of the court. The Clean Air Act, CAA, establishes a tripartite system for determining venue in CAA litigation. Challenges to nationally applicable Environmental Protection Agency (EPA) actions belong in U.S. Court of Appeals for the D.C. Circuit, while challenges to locally or regionally applicable EPA actions ordinarily belong in a regional circuit. But the CAA makes an exception for local or regional actions that are based on a determination of nationwide scope or effect, and accompanied by an EPA finding of this basis, which also must be challenged in the D.C. Circuit. Applying this framework to EPA's 2022 denials of certain small refineries' exemption petitions, we hold that the refineries' challenges belong in the D.C. Circuit. EPA's denials are only locally or regionally applicable, but they fall within the nationwide scope or effect exception. Section 7607B, 1. The CAA's venue provision governs where petitioners should file challenges to EPA actions under that statute. As originally enacted, Section 7607B, 1, dictated venue only for an enumerated subset of EPA actions. Certain actions with a national reach, such as any national primary or secondary ambient air quality standard, NOx, were reviewable only in the D.C. Circuit. Area-specific implementation plans went to the appropriate regional circuit. Any other unmentioned actions could be heard only in district courts through their general grant of federal question jurisdiction. In 1977, Congress replaced this patchwork system with the CAA's current scheme, which makes all EPA actions directly reviewable in a federal court of appeals. The amended statute specifies that, in addition to NOx and other enumerated actions, any other nationally applicable, final action taken by EPA under the CAA may be reviewed only in the D.C. Circuit, and, in addition to implementation plans, any other final action of EPA under this chapter, which is locally or regionally applicable ordinarily, may be reviewed only in a regional circuit. Congress has since amended the CAA to specify additional kinds of actions that fall within these two categories. Congress also created a third venue category in the 1977 amendments. This category provided an exception to the default rule that locally or regionally applicable actions should be reviewed in the regional circuits. Congress instructed that a locally or regionally applicable action must be reviewed in the D.C. Circuit if it is based on a determination of nationwide scope or effect, and if in taking such action EPA finds and publishes that such action is based on such a determination. The EPA actions at issue in this case relate to the CAA's Renewable Fuel Program, RFP. The RFP requires most domestic refineries to blend a certain amount of ethanol and other renewable fuels into the transportation fuels they produce. Each covered refinery's precise obligation turns on its proportional share of various nationwide volume mandates. Covered refineries demonstrate compliance through a system of Renewable Identification Number credits, RINs. A refinery generates RINs whenever it blends renewable fuels, and refineries may also buy and sell RINs. Thus, each year, a refinery may show compliance thanks to its own blending efforts, the purchase of credits from someone else, or a combination of both. The CAA contains a phased exemption scheme for small refineries, i.e., refineries whose average aggregate daily crude oil throughput for a calendar year does not exceed 75,000 barrels. The scheme exempted all small refineries from RFP compliance until 2011. It then required EPA to extend this blanket exemption, for at least 2 years, for all small refineries found by a Department of Energy study to face disproportionate economic hardship if subjected to the RFP's obligations. Finally, the scheme allows a small refinery to at any time petition EPA for an extension of its exemption, for the reason of disproportionate economic hardship. We interpreted this last provision in Holly Frontier, holding that a small refinery may obtain an extension even after its original exemption has lapsed. This case arose in the aftermath of Holly Frontier. Pending that decision, the D.C. Circuit had been holding in abeyance challenges to EPA's resolution of 36 small refineries' exemption petitions for the 2018 compliance year. Afterwards, that court granted EPA's motion for remand without vacatur, so that EPA could reconsider its orders in light of the Holly Frontier litigation. The D.C. Circuit instructed EPA to issue its new decisions within 120 days. Shortly thereafter, EPA noticed for public comment a proposal to deny all pending exemption petitions. EPA's notice set out two principles. First, EPA offered its interpretation of disproportionate economic hardship, the CAA's threshold for an exemption petition to be granted. On EPA's view, that phrase covers only hardship that is caused by RFP compliance. Second, EPA theorized that, as a matter of economics, small refineries ordinarily do not suffer disproportionate economic hardship as a result of the RFP because RIN costs are fully passed through to consumers. Based on this RIN pass-through theory, EPA proposed denying all pending petitions by finding that petitioning refineries do not face disproportionate economic hardship caused by compliance with their RFP obligations. After receiving comments, EPA followed through and denied the pending exemption petitions in 2 omnibus notices. EPA issued the first in April 2022 to deny the 36 petitions subject to the D.C. Circuit's deadline. EPA issued the second in July 2022, to deny an additional 69 petitions from the 2016 to 2021 compliance years. In both notices, EPA relied primarily on the principles from its proposal, namely, its statutory interpretation of disproportionate economic hardship and its RIN pass-through theory. EPA treated the pass-through theory as creating a presumption against granting exemptions, and it examined the petitioning refineries' evidence regarding their specific circumstances to confirm that none of the refineries had rebutted this presumption. EPA also asserted in the denial notices that its denials were reviewable only in the D.C. Circuit. According to EPA, the notices were nationally applicable actions under Section 7607B, 1. Alternatively, if the actions were only locally or regionally applicable, then EPA invoked the exception for actions based on a determination of nationwide scope or effect. EPA included in both notices a finding that its new statutory interpretation and RIN pass-through theory supplied the relevant determinations of nationwide scope or effect. Notwithstanding EPA's position, small refineries challenged these denials in a host of regional circuits. Agreeing with EPA that the litigation belonged in the D.C. Circuit, most of these circuits either dismissed the petitions for improper venue or transferred them to the D.C. Circuit. The Fifth Circuit took a different approach. Evaluating the petitions filed by 6 small refineries, respondents here, the Fifth Circuit held that the litigation was properly before it. The majority rejected the arguments for transfer raised by EPA and a group of interveners, reasoning that EPA's notices were merely locally or regionally applicable actions, because their legal effect was limited to the petitioning refineries. And, contra EPA, the notices were not based on any determination of nationwide scope or effect. Both EPA's new interpretation and its RIN pass-through theory failed to provide the agency with a sufficient basis to adjudicate exemption petitions, because EPA still looked to refinery-specific facts before it issued its denials. Accordingly, the case properly belonged in the Fifth Circuit, and the majority proceeded to rule against EPA on the merits, vacating and remanding EPA's denials for further consideration. Judge Higginbottom dissented on venue grounds. In his view, EPA's denial notices were nationally applicable because they applied throughout the country. EPA applied a consistent approach to small refineries spanning 18 different states, in the geographical boundaries of 8 different circuit courts. And, if the notices were only locally or regionally applicable, then EPA was correct to find that the nationwide scope or effect exception applied. EPA's statutory interpretation and its pass-through theory were core determinations that have nationwide scope or effect, in that they are applicable to all small refineries no matter the location or market in which they operate. We granted certiorari to clarify where venue properly lies. Section 7607B, 1, creates a 2-step inquiry for determining venue. At the first step, we assess whether an EPA action is nationally applicable, or only locally or regionally applicable. If the action is nationally applicable, then our inquiry ends. The case belongs in the D.C. Circuit. If the action is locally or regionally applicable, then we proceed to the second step. There, we ask whether the nationwide scope or effect exception applies to override the default rule that locally or regionally applicable actions belong in the regional circuits. Turning to Section 7607B, 1's first step, we hold that the actions before us are only locally or regionally applicable. To properly categorize EPA's actions at the first step, we must determine what the relevant action is, and what it means for an action to be nationally applicable as opposed to locally or regionally applicable. Once those principles are clarified, the categorization here is straightforward. Because Section 7607B, 1, pegs venue to the scope of the EPA action being challenged, our threshold task is to identify the action at issue. To do so, we must read action in its context. That word means a thing done. But we could define the thing done by EPA in different ways. Both EPA's denials of each individual exemption petition and its aggregation of those denials into omnibus notices are in a sense things done. The former is an activity the Clean Air Act allows the EPA to take, while the latter is how EPA has chosen to undertake that activity. To determine which framing matters for purposes of Section 7607B, 1, we look to the example actions this provision enumerates. Section 7607B, 1, lists various examples of EPA actions that qualify as either nationally applicable or locally or regionally applicable. For both these terms, it then provides a catch-all for any other final action. And, we interpret a general or collective term, in light of any common attributes shared by statutory examples of that term. The enumerated actions in Section 7607B, 1, make clear that this provision treats each activity the Clean Air Act allows the EPA to take as a distinct action. These actions all refer to particular exercises of EPA authority undertaken pursuant to particular CAA provisions. For instance, the example of a NOx must be understood by reference to Section 7409A, which directs EPA to issue a NOx for each air pollutant, and thus indicates that each pollutant-specific standard is its own action. Likewise, Section 7607B, 1's example of EPA's approval of an implementation plan under Section 7410 must be read in light of Section 7410, which makes clear that an implementation plan is a proposal submitted by a state, and thus indicates that EPA's approval decision is state-specific. In each case, the enumerated EPA action is defined by reference to the substantive authority under which EPA is acting. Accordingly, for both Section 7607B, 1's enumerated examples and any other final action taken by EPA under this chapter, we must look to the authorizing CAA provision to identify the action at hand. This provision makes the CAA's framing of the relevant action controlling, regardless of how EPA chooses to package its decisions in the Federal Register. The next question is whether a given action is nationally applicable or only locally or regionally applicable. Because Section 7607b(1) does not define those terms, we presumptively give those terms their ordinary meaning. The word national contemplates an activity with a nationwide scope, while the words local and regional relate only to particular places or regions. And the word applicable requires us to ask what the EPA action in question has reference to. Put another way, we ask whether the action on its face applies throughout the entire country, or only to particular localities or regions. The statutory context supplied by Section 7607b(1)'s enumerated examples confirms the correctness of this ordinary meaning approach. The actions that Section 7607b(1) identifies as nationally applicable facially apply nationwide. For example, courts have identified a NOx, a National Primary or Secondary Ambient Air Quality Standard, as the textbook example of nationally applicable action. Conversely, the actions that the CAA enumerates as locally or regionally applicable all have more particularized reach. For instance, the prototypical locally or regionally applicable action is EPA's approval of a state implementation plan, which, as explained, is state-specific. Because catch-all clauses are to be read as bringing within a statute categories similar in type to those specifically enumerated, the examples make clear that the ordinary meaning of the terms nationally applicable and locally or regionally applicable controls. Applying these principles here, we treat each EPA denial of a refinery's exemption petition as its own action for venue purposes. And EPA's denial of a single refinery's petition plainly is only locally or regionally applicable. This conclusion follows from how the CAA defines the submission and evaluation of an RFP exemption petition. The CAA allows a small refinery to at any time petition EPA for an extension of its exemption from RFP obligations. EPA, in turn, is to evaluate a petition and then act on any petition submitted, not later than 90 days after the date of receipt of the petition. Thus, the CAA pegs EPA's actions under the exemption provision by reference to each individual exemption petition. Against this backdrop, our classification decision is straightforward. By definition, EPA's denial of a single refinery's exemption petition only applies to that refinery, which is a particular entity located in a particular place. That limited reach makes EPA's denials paradigmatically locally or regionally applicable actions. We are unpersuaded by EPA's and the intervener's counterarguments. EPA proffers its omnibus denial notices as the relevant actions on the ground that it has the discretion to structure its decisions. According to EPA, it is free to aggregate similar petitions for joint resolution in a single action here. Its omnibus Federal Register notices, given its right as an agency to fashion its own rules of procedure and to pursue methods of inquiry capable of permitting it to discharge its multitudinous duties. But whatever discretion EPA has to manage its internal affairs, Congress conclusively defined the term action in Section 7607b(1) to focus on the specific statutory authority EPA is exercising. Tellingly, EPA's position that it can control the unit of action used to determine venue lacks any statutory limiting principle. If EPA had free rein to group decisions into a single action for venue purposes, then it could bundle even unrelated matters into one Federal Register pronouncement that is, in the aggregate, nationally applicable. Such a possibility would effectively give EPA a veto power over venue under the CAA. We see no reason to read Section 7607b(1) to permit such gamesmanship. Absent indication that Congress meant to give a party unfettered control over venue, we will not read a venue provision to confer such broad discretion. Because EPA does not dispute that the actions here can be nationally applicable only if it is right that the omnibus denial notices are the relevant actions, we need not resolve EPA's remaining arguments. At a minimum, however, we note that EPA's theory for distinguishing between nationally applicable and locally or regionally applicable actions cannot withstand scrutiny. EPA argues that any agency action is nationally applicable if it affects more than one circuit, but, as we have recognized, the term nationally applicable bears its ordinary meaning, and EPA's view would render actions with a plainly local or regional focus nationally applicable simply because the locality or region at issue straddles circuit lines. For example, some EPA air quality control regions cover metropolitan areas that extend into two circuits. It would defy credulity to say that an EPA action regarding such a region would therefore be nationally applicable rather than locally or regionally applicable. Whatever the precise line should be, EPA's line cannot be it. EPA justifies its position based on Section 7607b(1)'s language equating regional circuit review with review in the appropriate circuit. To be reviewable only in a single appropriate circuit, EPA contends, the category of locally or regionally applicable actions must be limited to those actions affecting only one circuit. But, in the absence of other evidence, Section 7607b, 1's use of the definite article "the" is too thin a reed to support EPA's conclusion. Finally, we find no merit in the intervener's arguments for why the denial of an individual refinery's exemption petition should still be considered nationally applicable. According to the interveners, the individual denials are nationally applicable because they have follow-on effects for the amount of renewable fuel that must be produced under the RFP, and because EPA in issuing the denials announced a new standard for adjudicating exemption petitions. But, again, we determine an action's range of applicability by looking only to the face of the action, rather than to its practical effects. Any follow-on implications of EPA's denials have no bearing on our analysis of their facial applicability. Because we conclude that EPA's actions were only locally or regionally applicable, we must proceed to the second step of the Section 7607b, 1, inquiry. That is, we ask whether the nationwide scope or effect exception applies to override the default of regional circuit review for locally or regionally applicable actions. This exception channels an action to the D.C. Circuit if 1. It is based on a determination of nationwide scope or effect, and 2. In taking such action, EPA finds and publishes that such action is based on such a determination. Here, all agree that the second requirement is satisfied. EPA included the necessary finding in both its April and June denial notices. Accordingly, the question before us is whether EPA's exemption denials were based on a determination of nationwide scope or effect. We conclude that they were. Here too, we begin by laying out the framework for deciding whether an action is based on a determination of nationwide scope or effect. We conclude that this requirement is met if such a determination supplies a core justification for EPA's action, and that courts should evaluate the basis for EPA's determinations de novo. Applying that framework, we hold that this case is one in which the nationwide scope or effect exception applies. To understand the phrase "based on a determination of nationwide scope or effect," we again turn to ordinary meaning. In particular, we look to the plain meaning of this phrase's component words, which are all terms of everyday usage, and we read these words in their context and with a view to their place in the overall statutory scheme. To begin, a determination is the settling and ending of a controversy, or the resolving of a question by argument or reasoning. In an EPA action, EPA's underlying determinations are the justifications it gives for the action, which can be found in its explanation of its action. In turn, a determination's scope and effect refer, respectively, to its formal area of operation and to its operative influence. An agency's determinations are of nationwide scope or effect if they apply throughout the entire nation. Taken together, an agency action involves determinations of nationwide scope if they apply throughout the country as a legal matter, de jure, and determinations of nationwide effect if they so apply as a practical one, de facto. Of course, nearly all agency actions can be said to involve justifications of nationwide reach or consequence. For example, most EPA actions presumably rely on EPA's interpretations of its governing statutes. The key question, then, is the degree of causality contained in the phrase "based on," and the meaning of that phrase is context-dependent. In many cases, it indicates a but-for causal relationship. But-for causation is a comparatively lenient standard, which is met so long as a result would not have occurred in the absence of, that is, but for, a party's conduct. In other cases, however, more is needed. Congress sometimes uses phrases such as "based on" to cover only core causes amounting to an action's sine qua non or gravamen. Section 7607b, 1, incorporates the more demanding, core understanding of "based on." This constraint follows from the function of the nationwide scope or effect exception as just that, an exception. Congress, after all, is unlikely to intend for an exception to swallow the rule. Thus, in this context, but-for causation is inadequate. In almost any case, a determination of nationwide scope or effect will be at least a but-for cause of EPA's action, given that any EPA action is downstream of EPA's conclusions as to what its governing statutes permit or require. But, Congress made regional circuit review the default for locally or regionally applicable actions, so we must read the nationwide scope or effect exception in a way that preserves regional circuit review as the norm. It follows that an EPA action is based on a particular determination only if that determination lies at the core of the agency action, so as to form the most important part of the agency's reasoning. Put more concretely, an EPA action is based on a determination of nationwide scope or effect only if a justification of nationwide breadth is the primary explanation for and driver of EPA's action. A determination of nationwide scope or effect does not rise to this level if EPA also relied in significant part on other, intensely factual considerations, or if the key driver of EPA's action is otherwise debatable. In deciding whether a particular EPA action is based on a determination of nationwide scope or effect, courts should assess EPA's reasoning de novo. This standard follows from the structure of the nationwide scope or effect exception. The exception applies only if a locally or regionally applicable action is based on a determination of nationwide scope or effect, and if EPA, in taking the action, finds and publishes that the action has this basis. In other words, the CAA requires both that EPA deem its action to have a qualifying basis and that the action in fact have this basis. This dual formulation does not naturally suggest that courts should simply give EPA's finding deference. The upshot is that courts must make an independent assessment of the scope of EPA's determinations. That is, they should parse the reasoning offered by EPA in taking an action to decide which determinations primarily drove the action. Courts routinely analyze filings to identify their substance, and the language of the nationwide scope or effect exception directs them to do the same here. In so holding, we do not downplay the importance of EPA's role. Because the nationwide scope or effect exception can apply only when EPA so finds and publishes that it does, EPA can decide whether the exception is even potentially relevant. And, where EPA does invoke the exception, its explanation for doing so will at a minimum focus the court's assessment of the possible determinations of nationwide scope or effect. Thus, EPA's choices will matter, even as courts must assess the basis for EPA's actions themselves. Applying this framework, we conclude that EPA's denials of the small refineries exemption petitions were based on determinations of nationwide scope or effect. We agree with EPA's finding, published in both its April and June denial notices, that its interpretation of the phrase disproportionate economic hardship under Section 7545.09(bi) and its RIN pass-through theory were determinations of nationwide scope or effect that formed the core basis for EPA's denials. Both conclusions are clear determinations of nationwide scope or effect. EPA invoked both its statutory interpretation and its pass-through theory in justifying its denials, and both points apply generically to all refineries, regardless of their geographic location. After all, the CAA is a federal statute, and Section 7545.09(bi), by its terms applies nationwide. Likewise, EPA's RIN pass-through theory is a finding about how the national refinery market works. These conclusions also can be deemed the basis for EPA's denials here. EPA decided, in light of the foregoing determinations, that it would presumptively deny all the exemption petitions before it. It then considered other, refinery-specific considerations only to confirm that it had no reason to depart from its presumptive disposition. In this posture, EPA's statutory interpretation and pass-through theory plainly are the most important parts of its reasoning. Or, put another way, where EPA relies on determinations of nationwide scope or effect to reach a presumptive resolution, those determinations qualify as the primary driver of its decision. EPA's confirmatory review of refinery-specific facts is merely peripheral by comparison. Accordingly, we agree with EPA that the nationwide scope or effect exception applies here. The Fifth Circuit should have transferred this case. We are unpersuaded by the counterarguments raised by EPA, respondents, the Fifth Circuit, and the dissent. Although we agree with EPA's bottom-line position that the nationwide scope or effect exception applies, we reject its roundabout approach to the word determination. EPA argues that the word determination in Section 7607(b)(1) suggests a resolution of an unsettled issue, such that EPA does not make determinations when it applies a previously established agency rule, policy, or interpretation to new circumstances. We agree with EPA that a determination here means the settling and ending of a controversy, but nothing in that term or its use in Section 7607(b)(1) suggests that only novel conclusions count. Rather, given Section 7607(b)(1)'s focus on the face of the agency action, determination is most naturally read to cover any EPA conclusion within the four corners of an action. Moreover, we do not see how EPA's proposed approach can be squared with its requested disposition. If a determination covers only the resolution of an unsettled issue, it is not obvious why EPA's June denials contain any determinations. EPA's June notice purported to apply the approach adopted in the April notice. EPA attempts to avoid this difficulty by proposing a holistic assessment of novelty that considers factors such as whether EPA announced the rule or policy at roughly the same time as the challenged agency action itself. But, we do not see how this amorphous test follows even from EPA's view. Respondents argue that the word determination in Section 7607(b)(1) is a term of art, wherein an agency action can trigger the nationwide scope or effect exception only if it is undertaken based on a CAA provision that textually directs EPA to make a determination for the entire nation. But determination is hardly a rarely used word, and nothing in the CAA's context suggests that Congress meant for its use in Section 7607B, 1, to reach only CAA provisions that happen to use some variant of that word. Such a limitation would at best lead to arbitrary outcomes, as Congress did not act in a standardized way when using determination as opposed to other words. At worst, respondents' approach would render the nationwide scope or effect exception meaningless. Respondents have conceded that their term of art view may render the exception a null set, or close to a null set. But Congress would not have gone to the trouble of creating a superfluous exception, so we will not force a term of art definition where it plainly does not fit. The dissent would similarly limit the nationwide scope or effect exception to reach only statutorily enumerated determinations, but its arguments fare no better. The dissent highlights that various CAA substantive provisions require EPA to make particular determinations before taking an action. But it does not follow that Congress meant to encompass only statutorily enumerated determinations when it spoke generally in the exception of actions based on a determination of nationwide scope or effect. And, although some statutes distinguish between considerations that inform a determination and the determination itself, statutes like the one in such use determination to refer to an agency's ultimate decision. In asking whether a determination supplies the basis for an EPA action, Section 7607B, 1, uses the term in a different sense. Likewise, the dissent's concern that our test could be difficult for lower courts and lawyers to apply is not a problem of our creation. Insofar as the reticulated venue framework that Congress enacted creates difficulty for courts or litigants, it is a problem for Congress, not one that federal courts can fix. Finally, we are unpersuaded by respondents' argument, accepted by the Fifth Circuit, that the nationwide scope or effect exception is inapplicable in light of EPA's consideration of refinery-specific facts. That exception requires that an EPA action be based on a determination of nationwide scope or effect, in contrast to another part of Section 7607B, 1, where Congress used the phrase based solely on. Accordingly, EPA's consideration of local facts does not preclude its invocation of the exception, either generally or here. So long as a determination of nationwide scope or effect served as the primary driver of EPA's action, other, more peripheral determinations are not relevant for venue purposes. We agree with the Fifth Circuit that EPA's actions here are only locally or regionally applicable, although we clarify that the relevant actions are EPA's individual denials of the small refineries exemption petitions. But, under a proper understanding of Section 7607B, 1, the nationwide scope or effect exception applies, and the case belongs in the D.C. Circuit. The Fifth Circuit therefore erred in denying EPA's request to transfer. The judgment of the Court of Appeals is vacated, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Justice Gorsuch, with whom the Chief Justice joins, dissenting. Though I would reach a different judgment, the Court and I travel much of the way together. This case involves 6 small refineries. Each petitioned the Environmental Protection Agency for a hardship exemption from the Clean Air Act's renewable fuel mandates. The agency denied all 6 refineries' petitions. The question we face does not concern the merits of what EPA did, only where the small refineries' lawsuit challenging the agency's actions should be heard. The Act instructs that litigation over nationally applicable EPA actions belongs in the D.C. Circuit, while disputes over locally or regionally applicable agency actions generally belong in a regional circuit. In Parts 1 and 2 of its opinion, the Court concludes that these rules presumptively route the dispute before us to a regional circuit because EPA's decision to deny an individual refinery's petition for a hardship exemption is a locally or regionally applicable action. With all that, I agree. But then, in Part 3 of its opinion, the Court pivots. Even when a case challenges only a locally or regionally applicable action, the Court observes, the Act routes it to the D.C. Circuit if EPA's action is based on a determination of nationwide scope or effect. Applying a new multi-step test it announces, the Court concludes that EPA's actions at issue here were based on such a determination. As a result, the Court holds, the right venue for this case turns out to be the D.C. Circuit after all. In my view, that pivot is a mistake. The Clean Air Act's venue provision works in harmony with its substantive provisions. Throughout, those substantive provisions direct EPA to make certain determinations before it may take certain actions. When it comes to acting on a small refinery's hardship petition, nothing in the Act's substantive provisions calls on EPA to make a determination of nationwide scope or effect. Instead, the Act requires the agency to evaluate only whether a particular small refinery seeking an exemption would suffer a hardship without one. Accordingly, the Act's venue provision routes this dispute to a regional circuit, just as the Fifth Circuit recognized below. The Court's new and reticulated test for assessing venue disputes under the Act strikes me as both mistaken and likely to render simple venue questions unnecessarily difficult and expensive to resolve. Start with how I would analyze this case. The Clean Air Act's venue provision, found in 42 U.S.C. Section 7607b, 1, supplies three basic rules. First, challenges to nationally applicable agency actions must be brought in the D.C. Circuit. Second, challenges to locally or regionally applicable agency actions must be filed in the appropriate regional circuit. Third, as an exception to the second rule, challenges to locally or regionally applicable agency actions belong in the D.C. Circuit if they are based on a determination of nationwide scope or effect. The central question this case poses concerns the relationship between the second and third rules. When is a locally or regionally applicable action under the Clean Air Act based on a determination of nationwide scope or effect? As I see it, the Act itself supplies the answer. Working in concert with the Act's venue provision, the Act's substantive provisions tell us what kinds of actions the agency is lawfully authorized to take and when those actions may be based on determinations of nationwide scope or effect. Here, the relevant substantive provisions permit EPA to take a specific action, namely, the granting or denying of a small refinery's hardship petition. But, by their terms, those provisions do not call for a nationwide determination when the agency acts. Instead, the only decisions EPA must make are refinery-specific ones. Accordingly, the dispute before us belongs in an appropriate regional circuit. To appreciate how the Act's substantive and venue provisions interact, begin with a look at the substantive provisions addressing the renewable fuel standards that lie at the heart of this case. As a rule, Section 7545.0(2) requires the nation's fuel supply to include ethanol or other renewable fuels in fixed amounts that increase over time. But the Act also permits EPA to take various actions inconsistent with that general rule if it makes certain determinations. So, for example, Section 7545.0(7ai) allows EPA to waive some renewable fuel mandates based on a determination that enforcing them would severely harm the economy or environment of a state, a region, or the United States. Similarly, EPA may waive renewable fuel requirements based on a determination that there is an inadequate domestic fuel supply. Similarly again, Section 7545b, 4c2, and 3, permit EPA to waive other standards if it determines that extreme and unusual circumstances exist in a state or region. Beyond those examples, Section 7545 discusses various other actions the agency may take after making various other determinations. In all, Section 7545 uses the word determination or one of its cognates more than 70 times. Now apply these observations about Section 7545's substantive provisions to the Act's venue provision. If, for example, EPA waives a renewable fuel standard for a single state under Section 7545.0(7ai), based on a determination that implementing those standards would severely harm the economy of a state, Section 7607b, 1, would route disputes over that action to the appropriate regional circuit. After all, a determination about the economy of a particular state is hardly one of nationwide scope or effect. On the other hand, if EPA issues such a waiver based on a determination that implementing the renewable fuel standard in question would severely harm the economy of the United States, Section 7607b, 1, would channel any litigation over that action to the D.C. Circuit. The substantive provisions at issue in today's companion case illustrate the same point. That litigation revolves around federal air quality standards and the state implementation plans, SIPs, states must prepare to meet them. Section 7410 sets forth the general rules about what SIPs must contain and how EPA must go about assessing them. But that section also authorizes EPA to take certain actions inconsistent with those rules after making certain determinations. For its part, Section 7410 uses determination or one of its cognates more than 20 times. So, for example, Section 7410b permits EPA to extend the period for the submission of any SIP for up to 18 months wherever the EPA administrator determines necessary. And Section 7410g allows EPA to disapprove a governor's decision to suspend a SIP component if the agency determines that his decision does not meet certain statutory criteria, including whether the suspension is necessary to prevent substantial increases in unemployment. Now consider where the Act's venue provision sends disputes about EPA actions under these substantive provisions. Suppose EPA determines that it is necessary to extend the submission deadline for SIPs across the country, and the agency acts accordingly pursuant to Section 7410b. In those circumstances, an argument might be made that Section 7607b(1) routes disputes about that action to the D.C. Circuit. But if EPA acts pursuant to Section 7410G to countermand a governor's decision to suspend a SEP component based on a determination that his decision defies the Act's terms, Section 7607b(1) would likely send any dispute over that action to a regional circuit. With that much in hand, return to the question whether the Act's venue provision directs this lawsuit to a regional circuit or the D.C. Circuit. As we have seen, Section 7545 lays out the Act's substantive renewable fuel standards and generally requires refineries to mix a certain, and regularly increasing, amount of renewable fuels into the transportation fuel they produce. But Section 7545 also allows EPA to exempt small refineries from these mandates for the reason of disproportionate economic hardship. Seeking to take advantage of this provision, the 6 small refineries before us individually petitioned EPA for hardship exemptions. In the end, the agency denied each refinery's request. Now, the small refineries seek to challenge EPA's actions in court. That challenge belongs in a regional circuit because nothing in the Act's relevant substantive provisions calls for EPA to act on a determination of nationwide scope or effect. Just walk through the substantive provisions addressing small refineries one by one. To account for the fact that small refineries may have more difficulty meeting evolving renewable fuel mandates than their larger rivals, Congress in 2005 granted them a blanket exemption until 2011. After that, Congress directed EPA to extend a small refineries exemption for a period of not less than 2 additional years, if the Secretary of Energy determines that the refinery in question would be subject to a disproportionate economic hardship if required to comply with the Act's renewable fuel mandates. Even beyond that, Congress permitted a small refinery to petition at any time for an extension of its exemption, for the reason of disproportionate economic hardship. When it comes to deciding whether to grant or deny such a petition, the Act directs EPA to consult with the Secretary of Energy, consider his determination whether a particular small refinery would suffer disproportionate economic hardship if required to comply, and consider other economic factors. Nowhere does the Act call for a determination of nationwide scope or effect. To the contrary, after the blanket exemption for small refineries expired in 2011, all agency actions and determinations became refinery-specific ones. Any doubt on that score is resolved by comparing these substantive provisions with others we have encountered. Section 7545(0)(7)(a), remember, allows EPA to waive certain renewable fuel standards based on a determination that implementation of the requirement would severely harm the economy or environment of the United States, or based on a determination that there is an inadequate domestic fuel supply. As that provision illustrates, when it wished to do so, Congress knew how to say that EPA may take a certain action based on a determination of nationwide scope or effect. That we have nothing like that here is a telling sign that the small refinery provisions work differently and do not task EPA with taking any nationally applicable action or making any determination of nationwide scope or effect. EPA's own statements convey the same message. The agency represents that it considers each petition on the merits and examines individual refinery information when passing on individual hardship petitions. EPA represents, too, that it determined that none of the petitioning small refineries merited a hardship exemption only after completing a thorough evaluation of the data and information provided by each small refinery. To be sure, EPA also highlights 2 features of its administrative proceedings that, it says, prove the agency took a nationally applicable action, or at least made a determination of nationwide scope or effect. For one, EPA emphasizes that it bundled the petitions from the 6 small refineries before us together with a host of other similar petitions and dispatched them all in a pair of administrative decisions. For another, the agency stresses that, in evaluating each refinery's petition, it relied on a single interpretation of the statutory phrase disproportionate economic hardship and a single economic model, the agency's RIN pass-through theory. The court correctly holds that none of this transforms EPA's challenged actions into nationally applicable actions. Yes, the agency may choose to bundle petitions together for administrative convenience. And, yes, the agency may apply similar reasoning when faced with similar petitions. But as the court recognizes, the only action the Act's substantive provisions call on EPA to take is to grant or deny an individual hardship petition, and that is a locally applicable action, not a national one. As I see it, this same insight defeats EPA's suggestion that its actions were based on a determination of nationwide scope or effect. As a matter of administrative convenience, the agency may choose to address a number of petitions collectively rather than separately, and the agency of course may, and, to avoid acting arbitrarily and capriciously, generally must, apply consistent reasoning to like petitions. But the Act's venue provision does not root cases to one circuit or another based on how EPA packages them or the quality or nature of its reasoning. Instead, the Act's venue provision asks whether the agency based its action on a determination of nationwide scope or effect. And, as the Act's substantive provisions make clear, EPA does no such thing when it passes on an individual small refinery's hardship petition. Turn now to how the court resolves this case. As we have seen, the court first holds that EPA's decision whether to grant or deny an individual small refinery's hardship petition is a locally or regionally applicable action. Accordingly, the court starts with the correct presumption that the suit before us belongs in a regional circuit, but then the court reverses course. While EPA's challenged actions are local or regional ones, the court concludes, this case belongs in the D.C. Circuit because the agency's actions were based on a determination of nationwide scope or effect. That portion of the court's opinion strikes me as both mistaken and likely to cause confusion about where Clean Air Act disputes should be heard. To understand why, consider how the court proceeds. Pursuing what it calls an ordinary meaning approach, the court observes that the word determination often refers to the settling and ending of a controversy. Extrapolating from that dictionary definition, the court reasons that any EPA conclusion within the four corners of an action qualifies as a determination. But, the court continues, whether an action is based on a conclusion of nationwide scope or effect depends on a degree of causality. Nor will just any degree of causality do. Proving that some nationwide conclusion, or now, the court adds, justification or reasoning, is the but-for cause of the agency's action will not suffice. Instead, EPA must establish that some nationwide conclusion, or justification or reasoning, qualifies as the gravamen or core or driver of its action. And when EPA's actions rely in significant part on intensely factual considerations or when the key driver of EPA's action is otherwise debatable, that standard will not be satisfied. Applying all those ideas to this case, the court holds that all of EPA's challenged actions were based on a determination of nationwide scope or effect. That is so, the court says, because EPA's actions, its decisions to deny the small refineries' petitions, rested at their core on a common, or nationwide, understanding of the statutory phrase disproportionate economic hardship and a common, or nationwide, economic model. To be sure, the court acknowledges, the agency also undertook a review of refinery-specific facts, but on the court's account, those refinery-specific facts mattered less to the outcomes here than EPA's statutory interpretation and its economic model. I find that chain of reasoning unpersuasive for a few reasons. For one thing, it seems to me pretty far afield from the statutory text. As we have seen, the Clean Air Act's venue provision speaks of actions and determinations, and the Act's substantive provisions do too. And when a substantive provision calls for either a nationally applicable action or a determination of nationwide scope or effect, it says so. To decide where a case belongs, then, no special judicially devised test is required. Instead, lawyers and judges need only open the statute books, find the relevant substantive provision, and follow its lead. As we have seen, the court takes just this approach when addressing the meaning of the term action in the Act's venue provision. There, it concludes EPA took no nationally applicable action, because the Act's substantive provisions peg an action to a decision to grant or deny an individual hardship petition. On my view, we should employ that same statute-driven approach to the meaning of a determination of nationwide scope or effect. For another thing, the court's test conflates a determination with the reasons that inform it. Statutes often distinguish between considerations that inform a determination and the determination itself. The Clean Air Act is no different. It authorizes EPA to take certain actions, like waiving renewable fuel mandates or disapproving a single governor's suspension of a SIP component. The Act authorizes those actions if certain determinations are made, like a determination that enforcing the renewable fuel mandates would severely harm the national economy or a determination that a governor's partial SIP suspension doesn't satisfy certain criteria. And to support its determinations, the agency may offer any number of reasons. To avoid accusations of arbitrary and capricious decision-making, too, the agency will usually employ consistent reasoning in like cases. But none of that means we should conflate the determinations EPA must make under the Act with the reasons the agency offers to support them. For another thing still, I worry that the court's test will prove tough for lower courts and lawyers to apply in practice. Having conflated a determination with the agency's underlying reasoning, the court must find some way to go about sorting and weighing all the reasons EPA may advance. But just consider what its approach entails. First, lawyers and judges must consult the full scope of the agency's reasoning, in this case, reasoning that runs over 280 pages. Next, lawyers and judges must parse out which aspects of that reasoning are particular to a locality or region and which are national in scope or effect. Finally, lawyers and judges must weigh those two sets of reasons against each other and decide which set was the true driver of the agency's decision and which was more peripheral to it. Litigation over whether the case is in the right court is essentially a waste of time and resources. When it comes to the simple preliminary question where a case should be filed, the rules of the road should be clear and easy to apply. The test the court announces today can claim neither of those virtues. For the lawyers and judges tasked with applying it, I can only wish them luck. To get a sense of the challenges the court's test poses for future litigants and lower courts, compare this case to its companion. As we have seen, that dispute involves SIPs, plans states must submit to EPA outlining how they intend to comply with national air quality standards. Among other things, a state's SEP must address the Act's Good Neighbor provision. Because air currents can carry pollution across state borders, that provision requires each SIP to contain adequate measures to prevent in-state emissions activity from interfering with other states' ability to satisfy federal air quality standards. In a single rule, EPA rejected 21 SIPs, including Utah's and Oklahoma's, because, in the agency's view, none satisfied the Act's Good Neighbor provision. Now Oklahoma, Utah, and certain industry groups seek to challenge EPA's actions in court, and they argue that their litigation belongs in a regional circuit. EPA responds that the SIPs case is, in every way that matters, like the small refineries case and thus belongs in the D.C. Circuit too. After all, the agency points out, it employed a common statutory interpretation and a common methodology to assess each state's proposed SIP, just as it did when considering the small refineries petitions. If the one case belongs in the D.C. Circuit, EPA argues, so must the other. Along those lines, EPA observes that, in assessing each SIP, it asked whether the state plan before it would contribute more than 1% of the permissible ozone level to a downwind state. In practice, EPA argues that 1% threshold proved critical. SIPs that fell under the 1% de minimis threshold were approved on that ground. Meanwhile, all, or nearly all, the SIPs that exceeded the 1% threshold, including Oklahoma's and Utah's, were rejected. Accordingly, the agency argues, even if it took a local or regional action with respect to each SEPI, nationwide determinations proved essential to EPA's reasoning in disapproving the state plans. The court disagrees. As it must under the test it announces, the court begins by consulting all the various reasons EPA offered. Some 60-plus pages of them appear in the Federal Register. In doing so, the court acknowledges that EPA used a common or nationwide statutory interpretation and a common or nationwide methodology when assessing all of the SIPs. The court recognizes, too, that the 1% threshold played a significant role in separating the SIPs EPA approved from those it rejected. Still, when it comes to weighing the role that EPA's common or nationwide justifications played, the court concludes they were not the primary drivers of the agency's challenged actions. Instead, factual determinations particular to the state at issue predominated. Relying on that assessment, the court holds that Oklahoma's and Utah's lawsuit challenging EPA's rejection of their SIPs belongs in a regional circuit. Maybe that's right, but I can certainly imagine arriving at the opposite outcome under the court's test. After all, EPA used a common statutory interpretation and a common methodology when assessing all of the SIPs, proceeding much as it did when evaluating the small refineries' hardship petitions. In both cases, too, the agency factored in certain local considerations, like individual state circumstances in the SIPs case, and individualized data and information in the small refineries case. Of course, the court thinks EPA leaned more heavily on individualized reasons in the SIPs case, and more heavily on common ones in the small refineries case. But without any objective standard for weighing which predominates, there seems to me ample room for good faith disagreement between litigants and among lower courts. And it is just that kind of ambiguity that promises protracted and expensive venue litigation going forward. To avoid that problem, I would resolve the SIPs case the same way I would resolve the small refineries case, by looking to the Act itself. Section 7410K(3) requires EPA to approve or disapprove SIPs and, in passing on them, to assess whether each individual state has or has not complied with its obligations under federal law. Nowhere does that substantive provision call for a nationally applicable action or task EPA with making a determination of nationwide scope or effect. And no more is needed to know that, under the Act's venue provision, the SIPs dispute before us belongs in a regional circuit. At the end of the day, venue rules are like traffic laws. They simply tell litigants where to go, and they should be easy to apply. As I read it, the Clean Air Act provides a clear rule for cases like this one. Applying that rule here, I would direct the parties to the appropriate regional circuit. The court doing otherwise, I respectfully dissent. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.